in terms of access to information. And of course, if you look at it, for example, especially in terms of information, persons with disabilities, you will agree with me, are one of the most vulnerable, or the most vulnerable, so to speak, in terms of accessing information. Sometimes we'll have beautiful legislations that will actually include person access to information. But the practical on the ground, persons with disabilities will not have access to information. I consider myself and my fellow visually impaired in terms of accessing information. For example, I always like quoting Article 2 of the UN Convention on the Rights of Persons with Disabilities. That talks about the right to persons with disabilities in terms of information or communication that should be made available in Braille format, in large print, soft copies, tactile, sign language, electronic or print media, that persons with disabilities can access in terms of at least the format itself. Because you remember, for example, myself and many other blind and visually impaired don't read this print, written scripts. How do we access information? It's either through Braille, either soft copy or electronic copies or tactile. If you go to the deaf and hard of hearing, how do they access information? The information should be available to them in some cases through sign language interpretation. So you can see that there are still restrictions or barriers in terms of accessing information by persons with disabilities. So if you talk of accessing information, all restrictions and barriers should be removed on our way. For instance, again, if you read Article 9 of the UN Convention, it is telling you that persons with disabilities should have the right to access public buildings, for example, wherever information could be available. And sometimes if you go to some of the are structured, wheelchair users will not be able to go and access information. Or sometimes if a blind or visually impaired person goes, will not be able to access information. Why? Either the information available there is not in an accessible format. So we are saying that it is the position of Gambia Federation for the Disabled that the government and other relevant stakeholders that actually has information that should be made available to all should ensure that all the barriers and restrictions are being removed from our way. If you go to schools, for example, the same thing, the books you will find in those schools are not in accessible format. So there again, blind and visually impaired are restricted. If you go to offices, for example, I got this manuscript very late that is available in ink print format. So obviously, because of time or whatsoever, it is the hard copy that is available for me. I would have preferred it at least to be sent to the Federation's email through soft copy so that I will be able to access it. Or perhaps the National Assembly here should have at least a Braille printing press or a Braille printer to ensure, because we have at least a National Assembly member here, so that any other information that is to be discussed or debated, it will be printed in Braille format, and she will also be able to use that format in order to access the information. Or if it is printed in Braille version, then posted through the Federation's office, it can be available in Braille format. Or it can be available at least through email so that we can also access it. But so long as persons with disabilities are concerned, we definitely embrace this bill, because when I've seen persons with disabilities included in the bill, I say, well, it's a right direction, because at least it is important for persons with disabilities to be always involved in decision-making processes, in draftings, in programming, so that at least we can always share our plight with you to take into consideration. I need not actually say much, but I hope that since we are included, we have told you the freedoms or the right to access information, that barriers and restrictions should be removed on our way to access information. We hope that our plight will also be included in this draft bill. And of course, I've also seen that it is to be a specific provision, that in the event we also want to access information, if any government or stakeholders wants to place barriers or restriction, we can always quote the statute of the right of access of information to give it its legal effect that persons with disabilities have the right as any person to access information. And I hope so definitely it will capture the rights of persons with disabilities access to information with accessible format. Thank you very much.
Thank you very much. Thank you very much, Mr. Tuwali, for those brilliant suggestions. And I think when you look at the act on part 2, which is due to create, keep, organize, and maintain information, on section 2, subsection B, it says every public body shall create, keep, organize, and maintain its information in a manner which facilitates access to information as is provided in this act. B says arrange all information in the possession systematically and in a manner that facilitates prompt and easy identification and access. So which means then the onus would be on those public bodies to ensure that no one is left behind. The information that they keep must be easily accessible by any person. And this one, it doesn't actually, stop anybody. So, page 13, right? Yeah, page 13. Sub 2.
Yeah, section 13, page 13. Sub 2.
Page 13, sub 2.
Page 11.
No, that should be on page 11.
Page 11.
Page 13? No. So where is sub 2? Because you have 6, 7, 8, 9. You have 6, 7, 8.
Page 11.
Section 13? Subsection 2, where a person with a disability, exactly, yeah. I have it on page 11. So that one is duty to assist requesters. Where a person, subsection 2, where a person with a disability wishes to make a request, the information officer shall take all necessary steps to assist the person to make the request in a manner that meets the needs of the person with disability, which complies with the act. So I think, Mr. Kurbali, we just have to ensure that the entire population, especially the public bodies, know that when you make a request, they must give you the information in a format that can easily be used by people with disability, living with disability.
The word is shall,
Yeah.
really means mandatory.
Mandatory, exactly.
At least for the one we understand.
Yeah.
From whom the information was requested. But
Exactly.
then I am not just sure also whether the necessary measures that are stated, will actually be available at the time, and how long certain course will take, particularly when at least there is failure to provide at least these facilities.
Okay.
Because definitely it should also be timely.
Yeah.
Sometimes at the time information will be requested, also sometimes it's needed as immediate or as soon as practicable like any other person.
Now, yes, on the same, if you go to section 14 also, response to request, is actually also very clear that within 21 days, they need to really respond to the request that you've made. And that one, it doesn't actually differentiate, but based generally by any person. So within 21 days, they must respond to you. Or the failure, they have to give a reason why, and then again, there's another period of time that is given to them. But there's a time frame on which they have to respond to you. Huh? 30? 30 days maximum, yes. Yes. 16? Extension of time, exactly, yeah. Even if they need extra time to respond to you, they will have to tell you also, they will advise you that we need extra time to provide A, B, or C. Pretty much there's a time frame on which they have to respond to you. And if they don't provide that within that time, they may ask for an extension from you. Yeah. So in that case, I think if anyone wants to add anything, but I think that's pretty much covered in terms of the type of access and the extension of time.
So that's not a provision, for example, how if an extension of time is given and still nothing is done?
Well, there are offenses actually. At the end, if an information officer refuses to, I wouldn't say refuse, but if they couldn't deliver, we may term it as refusal. Because there's a time frame. Of course, there are. Law, yeah. Mm-hmm. Enforced, yeah.
In this, there's a mechanism, enforcement mechanism.
Yeah.
In the Incubation Commission.
Yeah.
So, especially it will be proactive.
Yeah.
And in that membership, there will be persons with disability further protect the rights of persons with
Disability, exactly.
There's this committee also to provide oversight,
Yeah.
to ensure that the commission is performing
Yes.
and delivering as per the act.
Exactly. All right. All right. Thank you very much. Do we have any other concern?
Well, it has to do with, I mean, the guardianship.
Yeah.
I mean, we understand that actually the Ministry of Justice sent in a bill, and they withdrew that, and they sent in another.
Another one, yeah.
And then it was a question of style, they said. But the one sent to us, we do not know whether this was the one that has been substituted, you know, because I am having section 13 on page 13 on mine, and in another version, I think there is section 13 on page 11. So I do not know which one we have. But then, okay.
It's the new version.
I think we have copies of that.
I just gave
Okay. Okay. Yeah. So yeah. So this is the latest version, and then when you look at this also, when you look at the guardianship also, originally it's given to Ministry of Justice. In the one that has changed, it's given to the Ministry of Information. So essentially, there should be a line ministry that should oversee the implementation and coordination of this act. The best practice, without any, the best practice is that you give it to the Attorney General, because it's a question of rights, not just not government information machinery. Yeah. So, and that has been changed. Probably, well, the National Assembly may want to see what obtains in other countries, but I mean, from our research, we find out that in most countries, it is the Attorney General who administers the act, not the Minister for Information. Yeah. Yeah.
We can take a look at that and also find
Yeah.
out in those respects if also they have a Ministry of Information.
Yeah.
Find out exactly if that's normally, dealing with particular ministries actually, but we can find out.
Yeah.
Find out what is the standard.
Yeah.
And also perhaps get back to the AU model law.
Yeah.
To see exactly who is the custodian.
Yeah.
We can take a look at that.
Yeah. Well, the AU medal law is particularly clear on the fact that it should be Attorney General, Minister for Justice. Yeah.
Because of the legal,
Yeah.
expertise and issues
Yeah.
surrounding the circumstance.
Yeah. 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 Yeah.
Where the time period has been extended in accordance with Section 15. Now, he or she is deemed to have refused the request. So after the refusal now, my contention is what next? So what can the person who request the requester do? Because sometimes maybe you may have an issue with somebody, maybe the information officer, so you needed information, the person will just say, no, I refuse your request. So from there now, what next? We don't see any other thing that the requester can make follow up if he or she is refused the information.
Look at page 15.
Deemed refusal. (17) Deemed refusal. 17B. 17.
Next provision 18.
Okay. Uh-huh.
It you can make representation against the refusal.
Okay.
Yeah, in any case, they're going to have a commission.
Okay.
Okay, and if I also may read the powers of the commission, the commission may determine and issue general directions for the hearing of the matter, including notification of parties. So you're going to see that, and issue specific direction, B, issue specific directions where issues of sensitivity to the state are concerned. And, the commission can take it up actually to order the information holder to provide the information. That's why we have the commission as a...
I don't like that discretionary rule there. I think it should be mandatory.
Mandatory, yeah.
Because again, if the discretionary
Yeah.
is not mandatory,
Yeah.
it may end in...
Which page?
Page 37.
You said me.
Yeah, we check, the commission has the power to issue written order obliging the production of information. So I think, probably what we are saying, maybe we make it mandatory.
Exactly.
Okay, the commission shall have.
The way it is framed, it makes it mandatory.
Mandatory,
Yeah.
yeah. Because it says the commission has the power to issue written orders obliging the production of information, be examined, reproduce, take, extract from, or hold information as long as it's necessary.
Yeah.
So I think the way it is almost like it's mandatory.
Yeah.
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 So I think that is, I think it's probably, yeah. Okay. Yes, Honorable.
As far as I read the issue, I think he was talking in, you did mention of exemption
Yeah.
of information.
Yes.
And the objects and reasons where you have respect to personal information about self-employed by public body, medical records, and communication with legal practitioners as well as security sensitive information. Now, in the bill itself, you're talking about exemption.
Yeah.
How do you exactly know a particular information regarding security sensitive? How will you establish that when it is not touched in the bill? What are some of those things? Very important. How is it discussion on the commission also to that a particular information is security sensitive, or do we have to make a provision for the bill as well? And the exemption itself, is not covered in the bill.
There are exemptions.
Exemption, yeah.
24, section 24, part 3.
Go to page 20.
Part 3.
Section 24 up to up to 35, from section 24 to 35. It's different reasons why information can be restricted.
Yes. Yeah. And Mr. Honorable Chair, we would recommend that you probably also look at the Swanee principles.
Yeah.
That is specifically about national security information and access to information. Maybe there are certain things that we have not consulted it, but probably there are certain things in it that you may want to look into at a more deeper level. The Swanee principles.
So the Swanee principle comes about the series of consultations with, world security leaders and, freedom of information actors and so on, to determine the intersection between national security, defense, and so on, and freedom of information, so that we don't harm national security just to promote freedom of information, but we also don't harm freedom of information in favor of national security. So the balance, so for National Assembly members, it's important you access. We can make it available shortly.
Now, the Swanee principle.
That's the Southern capital.
Yeah.
Formerly Pretoria.
Yeah. That's the all local name. All right. Thank you very much. And now the other area I have on that same exemption that Honorable Caesar was talking about is the extent of the exemptions. Here is saying the exemptions in this part are not exhaustive and may from time to time be expanded by the minister. Yeah. For me, I think there needs to be checks and balance in that particular one, because we cannot just wake up one day and the minister come and say, well, we're going to add this as an exception. I don't know what you guys think.
Well,
Yeah.
we have to remove that particular bit entirely.
Yeah.
And I
It's back there. That's page 29. Page 29 on top. Yeah. So we have but personally, I have a concern with that.
Well, it's highly recommended by both local and international experts.
Yeah.
That particular provision is now in line
Exactly.
with international standards.
Exactly.
best practices,
Yes.
And it is also open to abuse.
Yeah.
by the minister.
Exactly. So for me, personally, I think that one needs to be removed. Or if the minister wants to add additional exemptions, I think they need to do an amendment in the act. They can bring to Parliament, we review with consultations with the relevant stakeholders, and then once we agree, then we can add the amendment on it. But we cannot just open it like that, where the minister can come and, we just wake up one day and say, okay, this is an exemption we're going to add. So for me, I think that one we really need to remove, and that's going to be part of our recommendations. Yes, 638, yeah. Yeah, 638, yeah.
I think that suggestion is the right one.
Yeah.
But certainly, there may be need to expand the exemptions.
Yeah, in the future. Exactly. Yeah.
But just that the minister cannot sit in his office on
Yeah,
his own
exactly.
and put things in the act. So whatever exemptions should be, in the act.
Exactly.
And that would require that come to the
Parliament, exactly. Exactly. Thank you. Thank you very much. Do we have any other? I think I have something on page 33. Yes. It's on page 29.
Yeah, there are different
Section 38, extent of the exemptions.
What we have is different.
Huh? What? Yeah. No. Well.
Can you provide us with copies of the blue one if that's the one you're working with?
No, we are working with this.
The red one.
Well, the one sent to us is.
No, the blue one is withdrawn.
They withdrew that one. You know the first one, they withdrew that one and bring another one.
That was my, because when I started reading it,
Yeah.
I discovered that,
The one with the red thing, this one.
Yeah.
it's been brought back.
Yes.
But then I found that section 5 is still in the copy that I have.
Yeah.
I said, maybe this is the one that has been withdrawn.
Yeah.
But I said, oh no, maybe they've made some adjustments and, so I didn't know.
Okay. Have you given him a copy?
I gave a copy to
Yeah, that's the one the minister brought to us as the final one.
Okay.
So maybe you can take a look at the one and see if
It's
anything
with
missing.
Madi,
Yeah.
I just-
Might be giving one to Madi, and maybe you can give him one as well.
I gave
Do you have the same thing?
Yes, we have similar.
You give them one.
I just
Oh, you have one. Okay. Yeah, exactly. Yeah. So if you look at that one, it's on page 29. That's where we have the extent of the exemptions. So that's the one we really think needs to be reviewed. Yes, Mr. Debo.
Yeah, I was part of this extent of the exemption.
Yes.
This is a very delicate area.
Yes.
And if the minister cannot
Yes.
expand the section,
Mm-hmm.
we should provide our help.
Mm-hmm.
These are very dynamic process. And the situation is national aware. Exemption may need to be extended. If such situations arise,
Mm-hmm. What?
and the minister is now not able to
Mm-hmm.
grant expansion, what do you do?
Actually, thank you. Thank you very much. I understand.
Yeah.
Actually, my suggestion in whole actually says exemption in this part are not exhaustive and may from time to time be expanded by the minister with approval from the National Assembly Select Committee responsible for this act. That's what I have on my record.
Or in consultation with the Minister of Justice.
Let it just be the preliminary, I think. Select committee.
No.
approval of an amendment.
It's also a question of what exemptions provided. If it is not information question, or it is an economic interest. I mean, if not this, what else do we want to exempt?
Exactly.
Is there a need for it?
There may be. Oh, yes.
What could we think about?
No,
The national security one, it is not a personal, it's not about my personal information. It's not about the economic interest of the state or of a private entity. And it's also not about international relations, which should be done, in that kind of, environment. Our take is that are quite adequate. Room to do A, B, C, but then it's also a question of what else do we want to examine.
Yeah. So basically, in fact, if you have anything that you think maybe the bill doesn't cover, maybe we can add it. We can do that before your final version. And that's the reason why it's actually still open.
This is a very interesting convergence. If legal issues are now coming up. Our sister Sabali drafted it under a contract. Why don't you get back to our sister Sabali and raise some of these concerns with her? She's a very able lawyer, So she might be able to expand. So,
an expert from
adequate.
Expert from Canada, from US, and we brought in Article 19.
Okay.
In fact, we've gone beyond the recommendations given by Article 19 when it comes to exemptions that are provided. We've gone beyond some of the recommendations because they think that actually, because the international standards are that you have to make it adequate, but then you also have to seal it. Yeah, so that it's not an open-ended thing that anyone can abuse anytime.
And again, as a member of the African Union, when you look at their model law of the African Union on access to information also, for me, that's why I was comparing what we have and then the model law. Yeah. And you're going to realize that actually, I can say almost 99% is in fact...
word for word, yeah.
Yeah. In fact, some sections actually is the way it is in purely is done. Yeah. Even though the model law gets to be, rectified. But for me, I think it's a good start to help, when we are doing the legislation. Yeah. So for me, really, my contention is like just want to make it open. Yeah. You know what happened? Like, remember 2 years ago, 3 years ago, when the IGP just came and said, well, all tinted glasses will have this, or we have to pay whatever it is. Yes. I mean, you can't just have those kind of, policies just like that. People need to know. People need to understand the rationale behind it. Personally, actually, I call it to find out the rationale behind what we are saying. $5,000 for tinted glasses, just an example. We cannot have those things. Let's have the laws, and if we need to add or to remove anything, come back to Parliament as the main lawmakers, and then we remove it or we add it. Yeah. For me, that's what I do. Yeah.
Okay.
So, do you have anything else that we can add? No, anything.
In general.
On behalf of the Minister, we wish to thank you for continuing this meeting. We will help and further enrich this bill that we are all feeling fast. Like our colleague from the GP has already mentioned, this whole initiative was, came from them. And as a ministry, we really thank them for such initiative, along with the other CSO that, supported the process. I think this endeavor is a demonstration of, how government can partner with CSOs to be able to achieve, our national development agenda, this is an important endeavor. Government was supposed to do, but giving a lot of factors, resource, our priorities as a ministry, and also the fact that we are resource constrained, we would have done this, but I'm sure it would have happened now, given some of our challenges we are facing as a ministry. So we used to use this opportunity to thank them immensely for coming up with such an initiative. I'm sure it's already highlighted in the document. This bill, once enacted by the National Assembly and implemented as planned, will really help strengthening our governance structure as a government, and also in terms of making public institutions more transparent and also accountable to the citizenry, the people that we serve. We've also gone through the document. I also want to mention that the issue of the nomenclature changing from Minister of Justice to Moisi is not our making.
No, I know.
It's not our making. We did not push for it. And in fact, we did not even have time. The two ministries did not have time to sit over the issue and then discuss before it comes here. And that's why we have 102 observation, which we think we will also need to highlight in this meeting, which has to do with the commission itself. Because as a government, it's good when we are taking policy decision, we also look at the issue, its implication on all facets of the country in terms of the environment, if it has to do with environment issues, economy, and whatever. And then giving our current, economic situation vis-a-vis the mandate of the commission, as highlighted in the bill, we are wondering where there is need to establish a new commission. And the fact that I have gone through, I stand to be corrected, but I do not foresee this institution becoming a self-sustainable institution in view of the funding mechanism highlighted in this document. I stand to be corrected, but I do not foresee this to become a full, sustainable institution in the long run. That means that it probably has to depend on government for subvention, right across. So the question is the question of its viability. So it's viable, but do we want to go ahead as a government and establish a new entity, as indicated here? Can't we look around and see an institution where that already exists, but it be given an added cap on its whatever mandate to be able to take up this, mandate? And then the other issue is that we've seen the information officers been mentioned right across the document. And currently, yes, and deputy information officers. And currently we are in the process of recruiting. Already we've gotten approval during the last budget bylaw to create information officers in all ministries, which have now been created. Because we also we know the citizens have been crying for lack of information. So, and we think as a government, we're also trying to improve on that by way of, creating positions in all ministries where we'll have information officers. And one of their responsibilities is to be informing, in the ministry, because we have a government spokesperson who is hosted at the ministry. One of them is by providing information at their ministerial level on information that the public needs to know. We are also in the process of reviving website in all ministries, which have started, and one of their roles will be to be providing content, because we feel that in the past, yes, this website were there, but there is no actual, the admin officers were assigned, but that's not their job. They have other responsibilities, the content provision of this website suffered. So that's one of the reasons why we are creating this. And information officers have been mentioned here. So there is that we need clarity. Is it the same information officers, which the head of the cadre is the Director Department of Information Services, for able to be able to take up this mandate? Or can the Human Rights Commission, I'm just use it food for thought, because we really did not have, we received this document on Friday, so we really did not have time as a minister to be able to, go beyond and be able to do a proper consultation on this. But this is just food for thought, which we should share with us. Can't the Human Rights Commission be, given another mandate to, and so forth? So these are some of the observations we have as a ministry as far as this bill is concerned. And then the last comment or observation we've also seen is, I think it's in the last page, not the last page, on page, the one I have, I'm not sure where it will be here. That is the procedure for the appointment of members of the commission. I don't know what section that will be. The schedule, section 42.
Section 42.
The last section, the composition of the commission. Yeah, it's 57 on this document, but we have different. Yes, we have different documents. I'm not sure. It's section, it's schedule. That is schedule.
Procedure for the appointment of members of the commission. Section.
Schedule.
The schedule, that is schedule. Anyway, schedule, that's what we have. So I'm not sure where it is in the current one.
No, there is a schedule, and that talks about the appointment process.
Yes. It also highlighted, it did indicate that the one I had is schedule 2B, where it says a representative of government. It's not clear which institution, which ministry. I don't know.
It's not part of the bill that's given to us.
But that was what was given to us.
It's in the bill.
It came from you. That was what was attached to the invitation letter.
Which page?
Page 57.
On the one we have is
The one we had is 57.
In fact, my 57 is off.
Okay,
That hasn't been.
it's here.
So I don't know. But it seems as if it's not in the
Yeah.
the one you just gave us. Yes. That was the one that was attached.
So in the copy that you have, it should be inside the bill.
Oh,
Because the minister during that debate was saying that he removed it from that page and brought it, as
okay, yeah,
part of
we can discuss because maybe it's somewhere, but I don't see it.
Yeah,
We cannot.
It's in the,
Yeah.
the new
no
one.
longer associated.
It's not.
Yeah.
Yeah.
So what's his concern there?
Well, it says.
32, huh?
Yeah.
Section 42, yeah. Section 42 in the copy that you have. In ours,
What page is it?
What page? What page?
Page 32. Not in yours. Oh, this is
No,
yours.
We have a new
there
one.
is a new one, yeah.
Give me
Section 42.
32.
Yes, that is here.
You talk about section
42, yeah.
Yes.
commission.
Yes.
All right. Here I have section 1.
It has changed here.
I think it has changed.
Consists of 5
5
commissioners.
commissioners.
One of whom shall
One
be
commissioner.
chairperson. B, number 2, members of the commission shall be appointed by the president on the recommendation of the minister and with the approval of the National Assembly. And number 3, these commissioners shall hold office for 5 years and shall be eligible for reappointment to a further term of 5 years.
Okay.
And 23 is the 43 is,
And then you have the criteria for the 3.
Aniko, the former one, it did highlight those that should compose the committee, which is you have the representative from each of the umbrella organization, the associate of the non-government organization, Gambia Bar Association, National Youth Council, Gambia Federation of the Disabled, National. That's the old version. Yeah, I don't know.
Because that one actually is talking about the.
And then it said government, but government is not clear. Which ministry under government should be part of it? That was not. But if it's clearly removed, then it's another thing. Yeah, it's removed.
So this is what is given to us.
Yeah.
That is not there. So.
Well, what we, I remember we had a discussion on this, and what we said was that in terms of composition and appointment, as it is in the Human Rights Act, National Human Rights Commission Act, will suffice here. So it's just a question of lifting that and then
putting it down.
Okay,
Yeah.
we can take a note of that.
Okay. It's not
Maybe we
highlighted.
can engage the Minister of Justice.
Yes.
So that we are on the same page.
Yeah.
Maybe you can take a note of that.
Yeah.
So that we can finalize it.
Yes.
For this section, this is the section.
independent commissioners.
Do we have anything else?
Well, I would love to comment on what the PS said about the issue of the commission. I think this is the most debated issue throughout the process. Should we create an independent commission or should we give the mandate to another commission? And we settled for giving it to an independent body. I mean, and of course, I must confess, I was among the people who think that it's either too big or maybe it should be given to someone else. But I was in the minority, and there's a great deal of, rationale in that, because the experience is that in some countries, they started with having this mandate under National Human Rights Commissions or Ombudsman. But a lot of them are now moving away from that system now, because what often happens is that these bodies get overwhelmed with issues of information request to a point that they can no longer deal with them with the efficiency that it requires. So those countries are now setting up
and some of them have already set up independent bodies that are looking into these issues. Of course, also it's a question of size. In some other countries like South Africa even, they have an information commission, one person. Some have 3, some have 5, some have up to 11. It depends on what we can do. But this is something that, of course, the National Assembly, in your wisdom, I mean, knowing how government is and how they work, you will have to make a decision on. But then our reason is that this is so important. It's the most important democratic institution besides the National Assembly that we are about to create here, definitely. But with respect to information officers, what the Act says is that the government should designate. So it could be the PS who will be the information officer for this, or it could be the people that you are appointing. But every institution should designate someone. So that's why we refrain from using the word appointment to designating. It could be someone who is already working, you just designate the person. It could be the PS, and the information officer that you are going to appoint will be working under the PS. But then this person shall have the authority to be able to decide what kind of information and when to give.
And I think further to our concern or issue she raised, it's important the body, the information officer or commission, is an independent body, which is also a standard practice. Just to ensure that there is no undue interference, there's efficiency, because when you put this under an existing public institution, then it means that body or that person, which is there to protect information rights of citizens, may face some control of some sort. And to ensure the integrity of that right to information, it is essential that this body remains independent. In terms of its functioning, yes, this is one of the functions of the state, so it has to take responsibility to provide it the necessary subvention to ensure that it functions, it performs its job. Certainly, it's not a profit-making body, but in addition, the Commission could be innovative in its own ways to seek funding from many other sources to sustain itself, because it's not just to sit there to receive requests or to make sure people get access to information, but the Commission also has a function to help public institutions build their capacity in terms of implementing this act. So that when you look at it really, if you have some very good commissioners, they could make it a very viable, vibrant, and a very active office that would be helping public institutions how to manage information, how to keep information, how to share information, and what structures are necessary, what training, capacity building is necessary. So it could be very useful eventually, But its independence is utterly important. Yes, that it remains so, and that is the practice in many places, democracies. It's an independent body, set up by law.
Yes, thank you.
I think just to add, I think the rationale is, like Sefu said, in some countries they actually give it to the Human Rights Commission. So maybe we can kind of consider for a start, it can be assigned to the Human Rights Commission, and then we gauge, the work they have. Because the example is Pura. In most countries, is actually different regulators. But in Gambia, Pura is a multi-sector regulator because of the economy. So I think for a start, we can do something like that. That's my suggestion.
Yeah, thank you. We can look at all those and let's see if that is the best way forward. Because again, access to information is a human rights issue. So
it is human
rights. Human Rights Commission, naturally, it is human rights. And just as a start, maybe we can take a note of that and then we can...
In fact, the example I can give you is, because we are on the verge of having the data protection and privacy bill. So one of the key thing is you have to establish a commission, because that is best practice. But we are considering, because, government is overwhelmed with establishing all these commissions, and you have to fund them. because that is key. You have to fund them, and we know the realities on the ground. You know, we all depend on the small taxes we are making. So we are actually considering also to pass that mandate to the Human Rights Commission or an entity that is established. So if the volume of work, you know, is relevant, then fine, you can kind of hive it off any time. But if you have an existing structure, I think it really makes sense. And of course, as official, it is our responsibility also to really kind of advise, you know, along those lines. Otherwise, you would not just establish an entity to be doing what, you know, because if the work is actually really huge, it makes sense. But if at all it's just the beginning and you wouldn't know, then I think it makes sense to really pass it, because data protection is actually coming, and then we're going to also establish another commission, you know. So we would just keep on, you know, establishing all these commissions, you know, and then you have to subvent them.
Thank you. And I think what can also help the committee as well from the ministry, if you can give us probably maybe the cost of running this particular commission, for example, in terms of the office, the rentals, if you have to rent, how you are going to pay the commission. Just an estimate. Budget, for example, just a budget. That would also actually help us first to take a look to see. What that means also is you have to augment the human, you know, they also exert capacity and stuff.
That's right, Honorable. So I think he makes a point.
Yeah.
You will see different regimes in different countries.
Yeah.
In some places, the Human Rights Commission encompasses the ombudsman. In other places, the Human Rights Commission is separate from the ombudsman, and so on. Data protection agency and access to information are separate. In some places, they are not. But then the balance is always budget and efficiency. Because if you put these things on the Human Rights Commission, it means the load increases. So they would have to have capacity. They would, some basic functions are there that they would have to have. And how would that impact on their efficiency to ensure that they protect these things? Even though right to information, access to information is a fundamental human right. Yeah, so, but that's a matter that the committee can consider. You know, I guess also have a discussion with the Human Rights Commission, whether they are prepared, given that we are just starting that institution as well. But not just us to look at today, but let's also look at tomorrow. I mean, Pura, like he said, is multi-sectoral, but I think it is now apparent it is important we remove the media element of things out of Pura and create something else, because, you know, the telephony, internet service alone is, not to mention utilities section, is so huge that, you know, and you don't want to sacrifice one, you know, sector at the expense of the other. Yeah, so what is going to be the future of our economy and society? So that why don't we start independent bodies right now and grow with them than to only dump them in one institution. Yeah, but these are all issues, I guess, your committee can engage various stakeholders to see what's the best out. Yeah.
Yeah, and thank you very much, Madi. And I think that would be important. If we can have the information as soon as possible, we can engage the Human Rights Commission to find out exactly, you know, the way they're thinking, whether there's some additional function that they can take. I'm sure they will need additional resources. I'm sure of that. But let's see exactly the thinking. And also, again,
additional commissioners.
Economy of this country, you know, is not really very strong. And again, it's very important that we try to put our foot according to the piece of code we have, not according to the size, but according to what we have, and then you know, and then we move on. So if you can have the information, we can consult with them, and then also at the end of the day, once we are done with our report, then we can engage the ministry again, Justice and Moise, about really what our recommendations are, so that we can refine it further. So when we go to plenary, it will be much easier for all of us to you know, do more forward.
Honorable Chair.
Yeah, thank you.
I think creation of this commission, I think the autonomy of these commissions are of great importance. Commissions highly depend on the government, and they are linked to the government as parastatals, and at the end, they are not being able to function as they're supposed to be. Look at all these good institutions that we have, commissions, but actually what do we end up seeing? That they are toothless. They are there, but they cannot bite. They cannot function as it is expected by the public. So what GPU is saying we need to consider it. And in creating new commissions now, I think we should consider their autonomy too, so that they will not fall into these past institutions that we are having here. Because of them, they are created and nothing can be done that is meaningful.
Yeah, thank you. I think we have everything on the table to discuss and then see the best way forward. Because at the end of the day, we just want a functional and very reliable company.
Yeah, yes.
That's what we're looking for.
Definitely.
Whether, it's going to be, on the
government
or on their own, but we just want it to be functional.
Functional,
and
yes.
then really we get what we are really looking for. I think we're going to put everything on the table, and then as a committee we can agree with the relevant ministries on the, on the way forward.
Exactly. Thank you.
I think, do we have anything else that we want to discuss?
Honorable Mo,
Yes.
The only thing that I want to talk about is to sensitize the Gambians to be able to be ready to share information. Because if you look at what is happening in the Gambia here, we are not willing to share information. Every time we talk, people will say that, this we should not talk about, these are confidential. And not all information are confidential. So in this area, I think, let us come with all these nice documents. Let us prepare them, but to implement them also is another issue. That is to sensitize the Gambians. We all know what I'm talking about. Gambians are not willing to share information, and these are issues that we really need to think about and see how best we make sure that these informations are shared. Thank you.
Thank you very much. Thank you very much. And again, last information relates to a lot of speculation. And if you want to reduce speculation, let's get the information.
Yeah.
And then we can reduce speculation. Are we all okay with the offenses, for example? If which is on the last page, which is section 76, about the offenses, which is a person who intends to deny a right of access to information under this act, destroys, damages, alters information, B, conceals information, C, falsifies, D, obstructs, E, interferes or obstructs the work of the commission, D, directs, proposes, cancels, or causes any person in any manner to do any of the above. Are we okay? No, I thought you have it, that's why I'm just summarizing it. It's on the page 50. Yeah. Which is the offenses. Yeah. And any of the above commits an offense and is liable on conviction to a fine of $100,000 or imprisonment for 6 months or both. Are we okay with the offenses? Again, this is talking about a person who intends to deny the right by falsifying a lot of, or are we okay with that?
I think the sentence is very limited.
Yeah.
6 months or 100,000. 100,000.
Yeah.
These are fundamental rights. So it shouldn't be easy.
Exactly.
Just damage it and just get 6 months. So
Yeah.
I think originally what we suggested was 250,000.
Exactly.
For 2 years.
Exactly.
Yes. So to reduce it to such, it's like a misdemeanor.
Oh, okay. For me, I thought the amount is just too low, because we must have a deterrent. Because again, when you're talking about a life and death situation, for example, in access to information, I think 100,000 or 6 months for me, I think is just chicken change. That's my view anyway. But we can.
That's where actually, even that we're dealing with also public bodies.
Public body, exactly. Exactly.
So 100,000
is maybe yeah. For me, that's why I'm asking whether are we okay with that. But for me, I think it's just too low. Yes, Honorable. Yeah.
Like if you have a community that's working for the National Assembly, and you go into the National Assembly, and then you want to update that information, the communication person would deny you that right to get the information because the National Assembly is not willing to give that information. Are you saying that person should pay 100,000?
No. When you falsify the information, for example, if I come here and make a request at the Hansard department about information about a particular sitting, sometimes 2 or 3 years ago, and somebody from there willfully go in there and then do all this, change and just give me falsified information. So we are talking about that particular person. Or if somebody, an institution refused completely to obey these things, what do we do? Exactly, because of the person of information officer works for the institution. You are representing the institution. Exactly. Well, that's from where we are. From the institution. Yeah. 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 The public body, yeah. Yeah. Exactly. Exactly, yeah.
Let me just share this experience with you. Let's say in law, sometimes if you look at the relationship, for example, between the employer and the
employee, yeah.
Let's say an employee can be working in an institution, employed by an employer, or sometimes do certain act, and if you do that act, like it is depending on that person who is affected. So that employee could actually be sued in his personal capacity. That is if the one affected likes it that way. But also if you want, as a joint, what we call tortfeasor, if affected, both the employer and the employee can also be sued together jointly by virtue of the action of the employee, because he at the time was also working in the course of his employment. You understand? That's why the law will tell you that a master is guilty for a tort committed by his servant, although guilty of no fault himself. So sometimes an employee can be working during the course of his employment, does something that affects somebody. So that employee may be sued in his own personal capacity, separately, or the employee and the employer can be sued and can be liable together. So sometimes also you can see, for example, if an information is requested or sought from an employee who during the course of his employment maybe refuses and it is established, so an option also comes. That employee may be sued personally or may be sued together with the employer. Yes.
So I think that's clear.
Yeah.
So we will start to clear what is
Yes.
That's 250,000 for 2 years.
2 years. Do we have anything else that we want to really discuss?
I wanted to regard the regulations.
Regulations, yes.
When you said that, I think it's better to think about them.
I don't know how will they end today. Yeah.
Yes. Without prejudice to the generality of subsection 1, regulation may provide for the term of office, salary and allowances of the commissioners and staff of the commission. Entirely is left in the hand of the minister to decide, or should that be checked?
Well, the regular, now our standing orders actually states that these regulars must be approved by the National Assembly. So that means even if they do, they still have to come back to us. Okay. Because that's fine. Because it's also talking about the fees for requesting information. The minister is going to be responsible to determine how much in the amount. So and this is about the public, and I think the National Assembly is about the public. So it's important that they come to the National Assembly to decide on behalf of. Okay. That's good. Okay. Anything else?
Well, under regulations. Yes. I think it is because what we have in the original is that the minister may make regulations for carrying into effect the purposes of the provisions of this act in consultation with the commission, and that's where we stopped.
Okay.
There are certain things in this which had gone through review and they were removed, such as A, B, C, and D. Because when it comes to D, we said that the manner of publication should be determined by the commission, not the minister. And the fees for reproduction also shouldn't be the ministers. And fees for request also shouldn't be the ministers. That's B. And the term of office, and in terms of their salary, I mean, this is clearly spelled out in the Act that commissioners serve a term of 5 years. And then their salary and their allowances should be equal to that of a High Court judge, as you have in every commission. So there is no need for you to have a minister who is now going to make regulation to those effects.
Yeah. So in effect, I think